Holographic imaging activated. Accessing files.
10, 9, 8, 7, 6, 5, 4, 3, 2, 1.
Activating light speed.
Slam dunk, are you ready to make me? I'm lit and I'm riding the fast lane. Don't let me down, I'm on fire. Does anyone else feel like a liar? It's all in your head and right. You just never use it.
All present. Session 2 of the Walker-Moot Supreme Court in the Canadian Bar Association courtroom is now in session. We would like to acknowledge that we are speaking to you today from the traditional and unceded territory of the Algonquin Anishinaabe people. We speak today while paying respect to the traditional knowledge keepers and the Algonquin people and all Indigenous people in the region of Ottawa who call the national capital their home. If you are not located in Ottawa and do not know about the traditional territory on which you are located, we encourage you to navigate to websites like nativeland.ca to find out. And we also encourage that you learn more about decolonization by consulting the TRC calls to action as a starting point. It is with great honor and privilege that I present to you Justice Colleen Byrne from Byrne and Tucker, Justice Reginald Watson from Miller Thompson, Justice Eric Horlick, Director of the Structural Heart Disease Intervention Service at the University of Health Network, Justice Dasha Pergaduba from Aird and Burles, and if she arrives, Justice Christina Morris, CRNA, a critical support specialist for the Frontline COVID-19 Care Alliance, presiding. The following are the facts of the case. On October 19, 2021, after battling COVID-19 for 18 days, Kyla Stark died in the ICU ward of Fallview Health 13 hours after her transfer from West Valley Memorial Hospital. Ms. Stark's medical records reveal that she was in perfect health and she had no previous existing medical conditions nor any prior family medical history that would indicate otherwise. She was double vaccinated as of August 1st, 2021. On October 1st, Ms. Stark tested positive for COVID-19 and contacted her longtime physician, Dr. Sophia Strange, and obtained a prescription for ivermectin. While pharmacies in her area were out of stock, Ms. Stark's condition was stable. On October 5th, Ms. Stark was notified that her local pharmacy had just stocked ivermectin and her prescription could be filled. But that same day, Ms. Stark developed severe shortness of breath and mild hypoxia and was admitted to the defendant's hospital, where she was placed under the care of Dr. Myrtle Papadopoulos, a third-year medical student. Ms. Stark immediately requested Dr. Papadopoulos administered ivermectin, her family physician had prescribed, a course of treatment which he chose to reject. On October 6th, Ms. Stark was moved to the ICU and placed on a nasal cannula during the day and BiPAP at night. Ms. Stark was treated with the hospital's COVID-19 protocol, which consisted of dexamethasone and pure oxygen. On October 7th, ivermectin was administered after Ms. Stark's family pleaded with Dr. Papadopoulos. Within 11 hours, Ms. Stark's condition had improved greatly. However, the supervising physician on staff, Dr. Litzier, chose to withhold any further administration after being informed of Dr. Papadopoulos' use of ivermectin. On the evening of October 8th, Ms. Stark's condition worsened and she was sedated, intubated, and put on a ventilator. Almost immediately thereafter, Dr. Litzier was contacted by Dr. Strange, who strongly requested ivermectin continue to be administered in addition to the Math Plus protocol. In response, Dr. Litzier asked Dr. Strange to come forward with the relevant literature for which he was relying on so he could make a rational and educated decision, which was provided immediately after. Dr. Litzier determined his time would be better spent attending to his patients than reading what he referred to as propaganda. On October 10th, the ICU nurse, Dolores Patel, was convinced by Ms. Stark's family to speak with Dr. Strange over the phone. Dr. Strange pleaded with Nurse Patel to administer the Frontline COVID-19 Critical Care Alliance Math Plus protocol. Nurse Patel spoke with the attending physician, Dr. Andy Park, and convinced him to undertake Dr. Strange's request. Within 15 hours, Ms. Stark's ventilator was turned down, and Dr. Park and the hospital personnel began the process of trying to bring her out of the medically induced coma. On October 11th, Ms. Stark's condition had improved, at this point only having to rely on a nasal cannula. On the morning of October 13th, Ms. Stark's family was informed by Nurse Patel that the hospital had misplaced the ivermectin, but there was no need for concern as Ms. Stark was making great progress. However, Dr. Litzier once again assumed care of Ms. Stark, and upon learning of the patient's treatment course, chastised Nurse Patel and the medical staff for administering the protocol. Dr. Litzier then administered remdesivir to Mrs. Stark. Nurse Patel phoned Ms. Stark's family and informed them that Dr. Litzier had assumed care and denied any further administration of the Math Plus protocol. The family was unable to reach Dr. Park, who was volunteering in Sudbury. At 1:27 a.m., Ms. Stark's oxygen level began to drop and she became unstable. Within 3 hours, Ms. Stark was again placed on a ventilator. The family arrived at the hospital but was denied access due to the hospital's COVID-19 protocols in place. Ms. Stark phoned Dr. Strange and pleaded with her to get involved. Dr. Strange placed several phone calls and emails to Dr. Litzier, but after 4 unsuccessful phone calls, decided to drive down to the defendant hospital in an attempt to manage the situation in person. Upon her arrival, Dr. Strange was too denied access to Ms. Stark and was unable to speak with Dr. Litzier. Within 6 hours, Ms. Stark's chances of survival had dropped to 20%, and Dr. Litzier informed Mr. Stark that he had exhausted both his course of treatment and the COVID-19 protocol in treating Ms. Stark. Mr. Stark pleaded with Dr. Litzier to administer the Math Plus protocol and offered to sign a release, releasing Dr. Litzier and the hospital and any of its agents and parties acting on its behalf from any and all liability arising from the administration of the protocol to his wife. However, Dr. Litzier refused to administer the Math Plus protocol, and a verbal confrontation ensued outside between Mr. Stark and the medical staff, and security removed him from the building. On October 19th, Dr. Litzier agreed to the transfer of Ms. Stark to Fallview Health, where Dr. Strange was on staff and would therefore be able to assume care for her. However, less than 1 hour after arriving at Fallview Health, Ms. Stark died. In this matter, the questions at issue are the following. Issue A, standard of care. 1. What is the requisite standard of care for medical negligence in Canada as correctly applied to this case? 2. Did Dr. Litzier breach the standard of care in failing to investigate the literature he was provided with and denying Ms. Stark treatment with Math Plus or ivermectin alone? B. Causation. Did Dr. Litzier's conduct cause or contribute to the harm or injury Ms. Stark sustained? Issue C. Vicarious liability. Is the hospital vicariously liable for Dr. Litzier's action? Justices of the panel, I present to you, speaking on behalf of the plaintiff, Mr. Stark, in today's matter before the court, Sydney Bristoll and Megan Sunga, and speaking on behalf of the defendant, Dr. Litzier and West Valley Memorial Hospital, Pearl Bakjtiari and O'Brien Boverhof. We are here today to determine the outcome on trial before the court on the matter between Mr. Stark, Dr. Litzier, and West Valley Memorial Hospital. Both the plaintiff and defendant's counsel will have 30 minutes each in total, 5 minutes for each counsel member to present their arguments to this court, including answering questions from the bench. The plaintiff will present their arguments first, followed by the defendants, and then a 3-minute rebuttal may follow if the plaintiff so choose. I will signal to the court when there are 5 minutes left per speaker with a little paper sign, and I will also put it in the chat. The court now invites counsel for the plaintiff to begin.
Good morning, Justices. My name is Sydney Bristoll, and I will be representing the plaintiff, Mr. Stark, along with my co-counsel, Megan Sunga. It is our submission that Dr. Litzier breached the standard of care of a reasonable, prudent, and diligent pulmonary and critical care specialist when he failed to read the literature provided to him by Dr. Strange and when he denied Ms. Stark treatment with Math Plus and ivermectin. The death of Ms. Stark and damages to Mr. Stark were caused by Dr. Litzier's breach of the standard of care. We also submit that West Valley Memorial Hospital is vicariously liable for the negligent actions of their staff physician, Dr. Litzier, as he is their agent. I will be starting our arguments by discussing the applicable standard of care in this case and the breach of the standard of care. Megan will then go on to discuss causation, vicarious liability, and damages sought. Starting off with the applicable standard of care, it is our submission that the standard of care for medical negligence in Canada, as applicable to this case, is that of a reasonable, prudent, and diligent pulmonary and critical care specialist. The requisite standard of care for medical negligence in Canada, as applied to a specialist physician, is articulated in Ternoisen and Korn. The standard of care of a specialist physician's conduct must be assessed against the conduct of other ordinary specialists who possess a reasonable level of knowledge, competence, and skill expected of professionals in Canada in that field. Additionally, it was held in Terra Neusen that a defendant will typically be exonerated of liability and negligence if they are found to have conformed to the standard practice at the time of the impugned act. However, merely because a practice is standard does not mean it is determinative of the issue of standard of care, and a standard practice may not rise to the civil standard of a reasonable person if that practice is so fraught with obvious risks that any layperson would be capable of finding the standard practice itself negligent. To clarify, physicians are not held to a standard of perfection. According to Still and Obidkoff, to establish a breach of the standard of care, a plaintiff must show that the defendant's physician's conduct rose above that of a mere error in judgment, to the level of unskillfulness, carelessness, or lack of knowledge. As Dr. Lutzier is a pulmonary and critical care specialist, the standard of care applicable to him is that of a reasonable, prudent, and diligent pulmonary and critical care specialist. Moving next to Dr. Lutzier's breach of the standard of care. It is our submission that Dr. Lutzier breached the standard of care when he failed to investigate the literature on Math Plus and ivermectin provided to him by Dr. Strange. Dr. Lutzier also breached the standard of care when he denied Ms. Stark treatment with Math Plus and ivermectin. I'll first discuss Dr. Lutzier's failure to investigate the literature on Math Plus and ivermectin. In their depositions, Dr. Titchener and Dr. Moriarty, as well as Dr. Strange, all agreed that the standard of care in this case required that the attending physician do their due diligence to investigate when presented with reputable evidence supporting an alternative treatment that may help their patient. Dr. Moriarty further elaborated that if she were able to, she would read literature regarding a life-saving treatment forwarded to her by another physician, regardless of their reputation, if they sent her 5 randomized controlled trials on the treatment, and that a failure to investigate in those circumstances would be a breach of the standard of care. It should be noted here that the meta-analysis forwarded to Dr. Lutzier by Dr. Strange contained 30 randomized controlled trials on use of ivermectin to treat COVID-19. In sum, the expert evidence establishes that meeting the standard of care of the reasonable, prudent, and diligent physician in this circumstance required investigating the literature emailed by Dr. Strange regarding the safety and effectiveness of ivermectin and Math Plus. By electing not to read the literature emailed to him by Dr. Strange, Dr. Lutzier failed to meet the standard of care required of him in this circumstance. He justified this failure because he believed that Dr. Strange and the Starks were brainwashed anti-vaxxers. However, this is irrelevant. Dr. Moriarty's testimony establishes that in fulfilling the duty to do due diligence, it does not matter whether one physician holds negative perceptions about another. The fact that Dr. Strange forwarded Dr. Lutzier a meta-analysis containing 30 randomized controlled trials in support of a treatment that could have saved Ms. Stark's life at a time when her condition was deteriorating on a different treatment obligated Dr. Lutzier to investigate that literature to meet the standard of care. Now we'll move on to discuss Dr. Lutzier's refusal to treat Ms. Stark with Math Plus and ivermectin.
Counsel, just before you do, I did want to jump in with a quick question. I appreciate that the facts establish that that the doctor did make a conclusion that he wasn't going to review that particular set of literature for the reasons you set out. Should it have any bearing on our findings as to whether the doctor had previously reviewed any literature concerning the same medication or course of treatment? I don't think the facts establish what he was basing his opinion on. And I'm wondering whether your arguments about due diligence pertain only to when the literature was sent in that particular instance, or if knowledge regarding that particular course of treatment as a whole would change your analysis in any way.
Thank you for your question. So Dr. Lutzier previously had read one study of the 64 that were available and had based his whole assessment off of that one study. However, it's our opinion that reading one study, especially in a case where a woman's life was on the line, and I'll go on a little bit later to discuss her lack of consent towards the alternative treatment, obligated Dr. Lutzier to investigate that treatment a little bit more in order to form a fuller opinion and make a more evidence-based decision regarding whether to treat her with it.
Okay, thank you very much.
Right, now I'll move on to discuss Dr. Lutzier's refusal to treat Ms. Stark with Math Plus and ivermectin. So Dr. Lutzier breached the standard of care by failing to act in Ms. Stark's best interest while treating her. This is for two reasons. Firstly, he failed to act in her best interest when he ignored her clinical responses to treatment, and two, by failing to obtain her consent. It ought to have been reasonably foreseeable to Dr. Lutzier that by acting against Ms. Stark's best interest in these ways, he risked exposing her to adverse health impacts. Acting in Ms. Stark's best interest in both these regards required administering Math Plus and ivermectin. Therefore, this is what was required to meet the standard of care. Since we've just divided our argument here into two parts, I'll first start with the first argument. So I'll discuss Dr. Lutzier's failure to act in Ms. Stark's best interest when he ignored her positive clinical outcomes on Math Plus and ivermectin and instead maintained her on the ineffective hospital protocol. The Canadian Medical Association's Code of Ethics and Professionalism states that physicians owe a duty of loyalty to protect and further patients' best interests. The standard of care required of a physician in any circumstance, therefore, requires that they act in the best interest of their patients. Acting in a patient's best interest sometimes requires providing individualized care and consequently straying from standard protocols in response to clinical outcomes. Any standard that does not require a physician to adapt to act in their patient's best interests is fraught with such obvious risks that any layperson could assess it as falling below the standard of care. Given that Ms. Stark responded positively to the Math Plus and ivermectin treatment regime and negatively to the hospital standard COVID-19 protocol, acting in her best interests required providing individualized care and treating her with the regime that demonstrated effectiveness, so that being Math Plus and ivermectin. Dr. Lutzier did not testify as to whether the hospital's protocol allowed for individualized care to accommodate a patient's best interests. However, if West Valley Memorial Hospital's COVID-19 guidelines did not require that physicians act in their patient's best interests, then the guidelines fell below the standard of care and Dr. Lutzier in following them. Conversely, if the guidelines did require that physicians act in their patient's best interests, then Dr. Lutzier alone fell below the standard of care by failing to act in Ms. Stark's best interests when he denied treating her with ivermectin and Math Plus. In either scenario, Dr. Lutzier failed to act in Ms. Stark's best interest and consequently breached the standard of care when he withheld effective treatment. Now we'll move on to discuss, sorry, Justice, you're on mute.
Would you agree that the physician's entitled to use the wealth of clinical knowledge that he's acquired over time and the progression of disease?
Sorry, go ahead.
Would you?
I would agree with that. However, in the case of COVID-19, where it's so new and really we've only accumulated like a couple years of knowledge on it and new treatments are emerging, we would argue that Dr. Lutzier in this scenario had an obligation to investigate an alternative treatment as to treating Ms. Stark, especially given her deteriorating condition on the existing protocol.
And would you agree that the physician was very familiar with the degradation of the respiratory system and the lung tissue and the effect of the disease on the ability for oxygen exchange? So he's aware of the physical evidence that results in physical damage was present at the time. Is that what the facts indicate?
Sorry, could you repeat that question?
Well, in every case, would you agree that we have to be able to explain the decision in light of the physical damage or the physical evidence that we're aware of?
Yes.
And are you aware of the fact that the physician was aware that there was likely physical damage in the respiratory system of the patient?
Yes, I would imagine that he would be aware of that, being a doctor of his standing and experience.
If he's a specialist, a pulmonary specialist, I think you'd have to concede yes, he'd be aware of that. And
Yes.
what was the specialty of Dr. Strange?
I believe Dr. Strange was, well, she was Miss Stark's family doctor, and I believe she was also a critical care specialist, but I would have to double check my notes
So you're
for
not
that.
sure. Okay, thank you. That's all I have.
Thank you.
Could I
Okay,
ask a brief question?
sure. Yeah.
Sorry, not being a lawyer, I'm going to ask a very unfair question. You mentioned that you are concerned that the hospital's protocols may be falling below the standard of care. I was wondering if you were aware of any hospital in Ontario that actually had ivermectin or Math Plus as part of their protocols.
I'm not aware of any hospital that does. More the argument that I was making there, not necessarily that they needed to have ivermectin as a part of their protocol, but that they should have as a part of their protocol the ability for physicians to be flexible in treating patients that may respond differently to different treatments in order to best treat them.
You would agree that if no other hospital in the province had ivermectin or Math Plus as part of their clinical protocols, that actually using these medications or strategies would be considered outside the standard of care?
Well, sorry, I'm just going to think about that for a moment.
You can move on and address it later. That's fine. I just raised that as an issue.
Yeah, I mean, I think that it would be. I guess that's, sorry, I guess if it's proven that ivermectin is an ineffective treatment that shouldn't be used on COVID-19, which my partner will go on to discuss in causation why there is evidence that it is an effective treatment, then it would fall below the standard of care. However, as I mentioned a little bit earlier, just because something is standard doesn't necessarily mean that it always meets the standard of care. And in this scenario, we would argue that the standard of care should have accommodated for the use of ivermectin in the case of Miss Stark, when it was clear that her condition was improving on the treatment.
Sorry, not to pile on here, Council. I just wanted to specifically ask you to address, because I believe your friends make the argument that in administering the treatment, in this case, that actually would have fallen below the standard of care because it was such an experimental treatment, which they say has, no known benefits, despite what the family thought here, or maybe the specific circumstances of this case. So I'm just wondering how you respond specifically to that argument.
Well, our response to that is that well, we do have evidence that shows that it does have known benefits, but namely that Miss Stark's condition did improve every single time she was put on ivermectin, and every single time and it was twice that she was put on ivermectin and taken off of it, and there was a relationship that could be seen between her being placed on the ivermectin and her condition improving significantly, and then her being taken off and put on the hospital protocol. So in this scenario, we feel that it was clear that the ivermectin was benefiting her, and that it should have been continue to be administered to her so that she could continue to benefit from it.
Okay, thank you.
Thank you for your questions. I'll move on now quickly just to discuss the second portion here, where we talk about how Dr. Lutzier violated Ms. Stark's consent. So subsections 10.1 and 11.1 of the Ontario Healthcare Consent Act establish that physicians have a statutory obligation to obtain informed consent from their patients prior to administering any treatments. Since informed consent is required by statute, it must be included in any standard of care. Ms. Stark did not consent to being treated with the hospital standard protocol. Mr. Stark testified that neither him nor Ms. Stark were aware of the guidelines. Therefore, it cannot be said that Ms. Stark provided informed consent to being treated with the protocol. Additionally, Ms. Stark made it clear that she did not want to be treated with remdesivir. Therefore, she explicitly withheld her consent in this regard. And Dr. Lutzier's decision to treat her with the remdesivir nonetheless is a violation of Section 10(1) of the Ontario Healthcare Consent Act and of the standard of care in this circumstance. Consent is not only required by statute, but evidence shows that the psychological effects of patient buy-in resulting in a placebo effect can positively impact health outcomes. Bystad and Wynn found that the patient's expectations can in some cases be of greater significance with regard to outcome than the administered pharmacological substances.
Okay, I've got a question for you. So does the patient have a right to make a bad decision?
The patient does have a right to make a bad decision.
And on the flip side of that, if the doctor has as one of the pillars of what they're obliged to do is to do no harm, and if the physician thinks that the patient's making a bad decision, is the physician obliged to commit as opposed to omit? So is the physician obliged to do something that he or she thinks will do harm to the patient because he or she believes it's outside the standard of care? So in other words, I'm saying, is there a mandatory duty for the physician to proceed against their conscience and against their ethics as they understand them?
I'm not aware if there is a mandatory duty to do that, but I know that there is a mandatory duty for physicians to respect and not violate the consent of their patients. In Millett and Schulman, the court discussed how once a doctor is made aware of the preferences of their patient and whether or not their patient has consented to a certain treatment or not consented to a certain treatment, then they have an obligation to respect that, even if they believe that it would harm the patient. And the only exception to this is if the patient was unconscious and unable to consent. In this case, Ms. Stark, when she entered the hospital, was not unconscious. She was very able to consent or withhold her consent. And further, when she did become unconscious, her substitute decision maker, her husband, was able to communicate her decisions to the hospital staff.
So we're running out of time, but so it's your position that the patient's in charge of the treatment plan, regardless of the wishes of the physician. Is that where you land on this?
Well, yeah, I get, yes, in terms of consent, it is our position. Yeah. Okay. Well, thank you, everyone. And I will pass it on to my co-counsel, Megan, who will continue with the remainder of our arguments.
Thank you. Good morning, Justices. As stated by my colleague, I'll be discussing causation, vicarious liability, and damages. To start off with ivermectin MAF Plus in general, ivermectin was once seen to cure scabies and approved as an antiparasitic treatment. Its antiparasitic and antiviral properties led its discovery to aid in the treatment of COVID-19. MAF Plus protocol is a hospital treatment protocol that includes methylprednisolone, ascorbic acid, thiamine, which is B1 vitamin, and heparin, which is an anticoagulant. The objective of the treatment is to reduce harmful inflammation and clotting of the blood. It's our submission that Dr. Lutzier's was negligent in ignoring the literature introduced by Dr. Strange, which interfered with Ms. Stark's recovery and caused her conditions to worsen and eventually her death. Using the but-for test from the case law, Kaufman and TTC, but for Dr. Lutzier's failure to consider Ms. Stark's best interests, read the papers supporting MAF Plus protocol, and properly monitor Ms. Stark's conditions, she would have still been here today. Dr. Lutzier's stated that she entered the pulmonary phase of COVID-19, administering that the MAF Plus protocol would not reverse her injuries or stop her death from occurring. Respectfully, he did not research enough to conclude that Ms. Stark had no hope to live. He read one study and dismissed the rest of the 63 trials as being poor quality without investigating. Even if there was insufficient evidence for ivermectin MAF plus protocol to be effective in helping patients recover for COVID-19, the fact that her conditions aligned with the changes to her treatment can be used to infer to demonstrate that ivermectin and MAF plus protocol is effective for specifically Ms. Stark.
Okay, I'm going to interrupt you there. Is it enough that she's with us for an extra hour, or does she have to be here for until today, to use your words?
Thank you for the question. Sorry, can you repeat your question?
Well, is it enough that if the medication that the physician did not administer would have extended her life, is it enough that it extends it for 5 minutes, or does it have to be up until from the time of the incident to today, or does it have to be for life expectancy? Or what is it that you're talking about in your argument? You said that she would still be here today. So is it enough that it gives her a rally at the end of her life and she gets an extra hour? Or what do you need to prove to establish your cause of action, as you understand it?
From what I understand, our argument is that Dr. Letczner had accelerated her time that she had left, and we're discussing that by not giving ivermectin MAF plus, it had done harm, which accelerated her time of death.
Okay, and is a minute enough? Is a second enough? Like, what is it that you say that you need to prove to establish your cause of action with respect to causation?
As long as he accelerated, whether it's a second or minute, that is what we're trying to submit.
Okay, so a second is all you need. Is that your position?
Yes.
Okay, thank you.
Thank you. Twice Ms. Stark's condition was shown to have improved following administration of this treatment. It is our submission that on a basis of probability, ivermectin and MAF plus protocol would have facilitated Ms. Stark's recovery. Ivermectin and MAF plus protocol are effective and have been studied rigorously, such as in randomized controlled trials and double blinds. The ivermectin treatment for COVID-19 real-time meta-analysis showed 33 randomized controlled trial studies. Relying on Snell and Farrell law, which discusses that there may be uncertainties, especially in cases of malpractice, since not all science may be 100% certain for causation, we submit that based on probabilities, through her conditions changing and the scientific evidence is inferred she would have lived if she was treated with ivermectin and MAF plus. Snell and Farrell law states that causation may be inferred as a presumption that defendant may prove wrong. Furthermore, the World Health Organization has stated if ivermectin was used at the start of the pandemic, about 2 million people could have been saved from death. But for Dr. Letczner's violation of Ms. Stark's consent, her condition would have improved since he was barred from treating her with the hospital's protocol without consent and would have been forced to release her into care of Dr. Strange to try not to do harm, where she would have been treated effectively with ivermectin and MAF plus protocol. Had she been allowed treatment that she had consented to, meaning administration of ivermectin and MAF plus, her health would have improved and she would have survived. Ivermectin and MAF plus protocol are evidence-based, safe, and effective treatments. Ivermectin has 78 studies on COVID-19 on 85,743 patients with 57 to 70% improvement. In contrast, remdesivir was approved with only one study with 1,063 patients and only a 31% improvement. Dr. Letczner stated that the benefits of ivermectin did not outweigh the risks. Yet ivermectin shows a higher success than drugs deemed safe in treating COVID-19. Ivermectin had saved many lives with less than 1 death per year, while ibuprofen had about 450 deaths to no lives saved. Since ivermectin had caused fewer deaths than Advil, is less lethal than Advil and should be considered equally as safe. Dr. Lenczner claimed that ivermectin is ineffective and the risk to benefit ratio is too significant to use as treatment, does not rely on current literature. His failure to investigate ivermectin as potentially life-saving treatment, mixed with his refusal to monitor Ms. Stark and be responsive to her changing conditions, demonstrate that Dr. Lenczner caused Ms. Stark's condition to worsen repeatedly up to her death. He had many opportunities to change or read literature on the treatment, deny the treatment, and release Ms. Stark, but he refused. Randomized controlled trials for ivermectin showed 23% improvement in the late treatment cohort. Although the probability of the improvement during the late stage of infection is low, in this case, the facts are persuasive that Ms. Stark would have fallen into the 23% of people who showed improvement during late stage. Now moving on to vicarious liability.
Do you mind if I ask a question?
Yes, yes, please.
Sorry, the WHO lists ivermectin as being approved for use only in clinical trials. And Health Canada describes ivermectin as a drug that has resulted in increased controls to poison centers in treating COVID-19, not approved for therapy. Pierre Corey, who is one of the leads for FLCC, has had 5 papers withdrawn from the medical literature by editors. And specifically the meta-analysis you refer to relies heavily on an Egyptian paper that is mathematically impossible. And thus that paper has been called into significant question. So just on the facts, I know how you're representing ivermectin and the literature on ivermectin, but I would take, I have concern about the way you're representing the science on ivermectin. And I'm wondering if you could comment on that.
So on the science of, thank you for the question, firstly. On the science of ivermectin, we're discussing statements from FLCC and WHO. Although there's 5 retracted, the stance have repeatedly had switched back and forth from neutral to negative to positive. These statements were taken from papers at the time of the incident. Furthermore, sorry, what was the second part of your question?
So what is the scientific validity that you were quoting? The second is the retractions of papers that have been published, and specifically called into question Pierre Corey, who is one of the principals of FLCC.
Okay, I see. I would concede that I wasn't aware of the 5 retracted papers. Although the 5 retracted, there's 5 papers retracted, there's still many papers that are positive towards ivermectin. And earlier you also stated how the real-time meta-analysis was seen to have some papers that were not possible. Although there is that paper, there's many other papers that we're able to see when click the link, and there may be one bad paper, but it doesn't mean all of the papers are bad. Thank you. Okay. So I'll move on to vicarious liability. The test of vicarious liability based on the Bristoll in Canada case law includes there must be a tort and that tort was committed by an employee of a person or body against whom vicarious liability is sought, and that the tort was committed in the course of the employee's employment. We submit that West Valley Memorial Hospital is vicariously liable for Dr. Lenczner's negligent acts towards Ms. Stark due to Dr. Lenczner acting as an agent on behalf of the hospital. The tort in this case, we submitted medical negligence committed by Dr. Lenczner towards Ms. Stark. His negligent act was failing to consider what was best for the patient investigating and administrating ivermectin math plus protocol. Dr. Letczner stated that he is a full-time employee for the West Valley Memorial Hospital and received a salary, which is stated on 1C of the employee agreement. Furthermore, he explained that taking care of Ms. Stark was a duty he had taken on and was given to him as a hospital employee. He also stated that he acts on behalf of the hospital, and these statements describe his position as a West Valley Memorial Hospital agent. This is supported also by the contract clause 2B and 2C. Since he established that taking care of Ms. Stark was part of the duties assigned by the hospital as he employed, the negligent medical tort was committed during his employment. Moving on to damages. Mr. Stark seeks damages for loss of guidance and companionship. Furthermore, Ms. Stark will seek damages for Ms. Stark's pain, suffering, loss of dependency, income, and household services under Section 61 of the Family Law Act. Our submission to use DeBanco, Raimondo Estate, and Jackie Wicks as a baseline before the calculation is taken. In the case of the deceased 30-year-old from medical negligence, an estimation of salary of about $47,000, it was calculated that the loss of income dependency was $723,728, assuming she retired at age 65. Economic loss experts would be needed to calculate the loss of dependency income, and disclosure of Mr. and Mrs. Stark's income would be necessary. Similar to the deceased in DeBanco, Ms. Stark was 29 years old and the first wife of Mr. Stark. Therefore, Mr. Stark should similarly be entitled to $75,000 in damages for loss of companionship and guidance. Mr. and Mrs. Stark's 2-year-old child should be entitled to $35,000, the same amount awarded to deceased children in DeBanco. Ms. Stark was a general manager for Toronto Raptors Basketball Club. At the minimum, her husband should receive the same amount as the plaintiff in DeBanco. That case and those damages were awarded in 2001, and if same case were decided today, damages would be higher due to inflation. Furthermore, given her position, Ms. Stark's salary would be expected to be greater than $50,000. In conclusion, our submission that Dr. Letczner dropped below the standard by failure to consider her best interests, which required not violating her consent and responding to her responses to the treatment, and therefore administering ivermectin and MAF+. Mr. Stark seeks the order sought. Mr. Stark seeks compensation for the medical negligence committed against Ms. Stark by Dr. Letczner from West Valley Memorial Hospital because they are vicariously liable for, it's our submission that they're vicariously liable for their actions of their agent. Mr. Stark seeks $100,500 in general damages for pain and suffering and for loss of guidance, care, companionship, and for himself and his 2-year-old child. Furthermore, Mr. Stark seeks special damages of $723,728 for loss of dependency income. That would be our submission. Thank you for hearing our submission. If there's any more questions.
Can we agree that without an economic expert, everything you just said on damages is complete speculation? Because you don't have
Yeah.
any evidential foundation for anything you just said.
Yes, economic expert would be needed.
Yeah. And in any tort, the fourth element of a tort is proof of damages, correct? And causation has to link the breach of the standard of care to a loss. And really what you just told me is that you're unable to prove a loss, and in effect, are you admitting to me then that you failed to establish any evidence of the fourth essential element of the tort of negligence?
No, sorry. Respectfully, although we can't put a number on how much the loss of dependency is, there was a loss of dependency of income, and it's clear with with the loss of Ms. Stark, there is some damages, but the amount isn't calculated because we don't have an expert, economic loss expert.
Which, if this was a real trial, would be fatal to the claim, correct?
Yes.
Yes, thank you.
That is time for the plaintiffs, and the court now invites counsel for the defendant to begin.
Good morning, Your Honors. First of all, I would like to apologize for not having my background on. I've been having some technical difficulties, but hopefully my argumentation skills are better than my technology skills today. To get started, my name is Bakjtiari, and this is my co-counsel, Orion Boverhof. Today, we are appearing on behalf of the defendants in this matter, Dr. Justin Lenczner and West Valley Memorial Hospital. So I will begin by addressing the issues pertaining to the standard of care, and my co-counsel will address the issues of causation and vicarious liability. So at the heart of this case is the notion that holding medical experts to unreasonable standards will ultimately jeopardize the entire healthcare system. So while individualized patient input does play a role in determining treatment, the expertise of medical professionals as well as global health agencies should also be considered. A physician's time should be utilized in the best way possible to ensure the best possible outcomes for their patients, and they should not be forced to administer experimental treatments that they believe will cause harm to their patients. So first, we submit that the defendant did not reach the standard of care, as he took the steps that any reasonable and prudent doctor would in that scenario. Next, we submit that it cannot be determined on a balance of probabilities that Dr. Lenczner's conduct at issue caused or even contributed to the patient's death. Our final submission will determine that West Valley Memorial Hospital cannot be held vicariously liable for the actions of Dr. Lenczner, even if negligence were to be established. So, judges of the court, we urge you to find that Dr. Lenczner's conduct does not amount to medical negligence. We will demonstrate that not only did Dr. Lenczner meet the standard of care in this case, but his actions also failed to contribute to the causation of Ms. Stark's death. So, in addressing the first argument, we submit that Dr. Lenczner did not breach the standard of care by failing to investigate the literature, nor did he breach that standard of care by refusing to administer Math Plus or ivermectin. Members of the court, I submit that Dr. Lenczner did not breach the standard of care by failing to investigate the literature provided to him by Dr. Strange. So Dr. Lenczner used his expert medical discretion to overlook this information that was provided to him. I would like to point out that he did not entirely fail to investigate the literature, as mentioned by opposing counsel, as he stopped reading after the first study when he deemed the source to be of low quality and therefore not reliable. Additionally, Dr. Lenczner also testified that he was not relying on that sole trial, but a compilation of information which included the world's leading medical experts' opinions. So we have to remember that Dr. Lenczner is a medical professional with over 20 years of experience in the field, which should indicate that his medical discretion does hold some substantial weight. And so he can make the decision to disregard the various studies provided to him by Dr. Strange, as he is qualified to determine which studies are of appropriate quality and worth reading. And so I would like to mention that unlike the other sources sent by Dr. Strange, the one Dr. Lenczner read was written in a high quality and peer-reviewed journal, indicating greater credibility. And so because of that, it was actually appropriate for him to disregard the other 63 trials, which he believed to be of poor quality. Ultimately, he used his expert judgment to not waste time reading information that wasn't coming from a credible source. And so if Dr. Lenczner were to adhere to information from non-credible sources, the entire healthcare system would be jeopardized by allowing doctors to work based on findings that may not be scientifically valid. And so Dr. Lenczner's role as a practitioner does not require him to conduct his own research, but he can be reasonably expected to keep up to date with the evolving information in the medical field. So in his testimony, he said that He does so, he keeps his knowledge up to date by looking at high quality peer-reviewed journals and compilations of information from the world's leading medical experts. And so the common understanding of ivermectin currently by leading medical experts is that the current studies are inconclusive of whether ivermectin is an appropriate treatment for COVID-19. And so West Valley Memorial Hospital, along with the other top hospitals in the country, they adhere to a standard protocol for the treatment of a patient with COVID-19 for a reason. These standards rely on evidence-based medication that provides beneficial care. And so any deviation from the standard protocol for the use of an alternative method such as MAF Plus would be experimental in relation to COVID at least, rather than evidence-based, especially when this method has not been scientifically proven to provide any benefit for COVID-19. And so the question becomes, if we cannot rely on the general prevailing science brought forward by medical experts, who are we to trust? And so opposing counsel had mentioned that there needs to be a respectful dialogue between patients and healthcare practitioners, which promotes the best outcomes possible. And so it would be likely that this is true, but only when patients aren't acting against their own best interests, best medical interests at the very least.
I'm going to interrupt you there. So you're saying that, especially on the second set of administration of the standard protocol, that that information, as I understand it, was withheld from the patient, and the physician proceeded without obtaining informed consent, and you endorse that as the position of your client. Is that correct?
Your Honor, that is an excellent question and a very important point to address. And so to counter the opposing counsel's argument in terms of autonomy and—
How about you just answer the question?
Yes. So the Healthcare Consent Act actually does mention that any health practitioner who in good faith refrains from administering a treatment or administers a treatment is not liable for administering the treatment without consent. So ultimately, in this case, Dr. Lenczner cannot be held liable for medical negligence because in his belief, he was conducting his work in his best faith possible.
So he's entitled to hoodwink his patient. So he knows that the patient wants X. He doesn't like X, so he can sneak in Y, and that's okay. That's your submission on behalf of your client, that the client is not entitled to know of or participate in or make a bad decision or refuse with respect to the proposed course of treatment. That's the position of the physician. Is that correct?
Respectfully, Your Honor, the physician in this case was preventing the experimental treatment of his patient. So to say that administrating MAF Plus or the treatment that the patient wanted in that time would not be reasonable for him to administer, because there's nothing about the MAF Plus studies or the ivermectin studies that would persuade him to administer that for her. And doctors take the oath to not do any harm. So if he truly believes that that administration of ivermectin or MAF Plus would be harmful to her, there is no way that he should be administrating the treatment.
So he's entitled to trespass. That's your position. He doesn't have to tell the patient, I'm not going to do this, but I'm not going to tell you what I am going to do because I don't have to. That's your position?
Essentially, while patient consent and autonomy and—
That would be a yes or a no answer.
Yes, essentially
He's entitled to do that. He's entitled to disregard the wishes of the patients, which in effect then prevents the patient from refusing treatment because the physician's in charge and can completely disregard the wishes of the patient. That's your position.
Ultimately, yes, because
Okay.
if we—
That's good. Thank you.
Yep. Yes.
Sorry, so I think this is specifically also with regard to remdesivir as opposed to Math Plus and ivermectin. So if a patient, just to continue on this point, I just want to make sure that I understand your position because it's an interesting one. If a patient has specifically said they do not want a particular medication or therapy, you believe that it is fine for the physician to override that. Is that correct?
Ultimately, if the physician believes that that is the better course of action, according to statute, yes. According to the healthcare statute, yes.
Very well.
And so I know that I'm running out of time, so I will move on to the second submission. The second submission states that administrating Math Plus would be overriding the standard protocol, which is based on regularly updated guidelines created by experts for the hospitals to follow. And so the Math Plus protocol has not been scientifically proven to be more effective than the standard protocol, nor has it proven to have any benefits for COVID-19 treatment in general. So using Math Plus would be failing to adhere to the standard of evidence-based medication that uses beneficial care. And failing to adhere to this standard would be failing to act as a prudent and diligent physician in the same circumstances. And so moving on, the Korn case establishes that physicians are required to conduct themselves in accordance with the standard of their professional peers, but they are not expected to guarantee the success of their procedures or the perfect safety of their patients. And so we urge the court to remember that the standard is one of care rather than perfection. And the Everson case further establishes that the standard of care required by a physician is determined by considering the medical norms and determining whether the procedure in question fell below those norms. So in this case, while the standard of care failed to save Ms. Stark, this does not amount to negligence, as Dr. Lenczner appropriately exercised his medical judgment in a manner that was consistent with a prudent and diligent doctor. And so to legally scrutinize a doctor for adhering to standard protocols with proven benefits merely because it failed to save a patient whose cause of death was actually irrelevant to the procedure, as my co-counsel will argue, would be holding doctors to a standard of perfection rather than care. And so,
sorry, excuse me, counsel.
yes.
Is it your position that the doctor was entitled to disregard the positive benefits of the treatment during the period of time that it was administered, even though he was unaware? Is that not a factor he should have considered?
Sorry, could you repeat the question?
Yes, I'm saying in making his determination about what treatment to offer and what treatment to administer, was the doctor required to take into account, you're talking about evidence-based, but was some of the evidence he was supposed to take into account, was some of the evidence that patient's response to the treatment that she'd been offered?
Correct. So thank you, Your Honor. So I believe that it is the opposing counsel's position that he did fail to meet the standard of care because he ignored the clinical outcomes that she was presenting in the hospital. However, Dr. Lenczner actually holds that by the time that he had received Ms. Stark as a patient, she had already progressed to a point where it was irreparable based on her advanced fibrotic lung disease. And so her lungs were actually badly damaged at the time. So what you see there may not exactly be what the reality is. So it could be the position that Math Plus merely hid the damage and was happening and made her look better without actually fixing anything. So that would be treating the symptoms rather than the disease. So the clinical outcomes, which my opposing counsel have mentioned, are not entirely black and white as they may make it seem. And so for those reasons, it was appropriate for him to ignore the clinical outcomes in that specific scenario.
Counsel, I have a question as well, and if this is going to be addressed by your co-counsel, then that's fine. You can just indicate that. But I am curious, as somebody that doesn't deal with a lot of medical negligence cases, whether the offer of the release has any bearing, should have any bearing on this analysis, or whether it's a red herring. So I would like one of you to address that, please.
I believe Orion will be addressing that in his causation argument. But if not, I can circle back to that.
Thank you.
Just in the, just to keep the time in mind as well, because I know I am running a little bit short. So
That's fine. Thank you.
and that is time for me. Can I have a minute or two just to wrap up?
Yes, please go ahead.
Thank you. And so Dr. Lenczner cannot be found liable for the negligence in this case, as treatment that he administered to Ms. Stark directly corresponds with the position of leading medical experts, despite the competing theories about ivermectin existing. So it would be outrageous to state that a doctor failed to meet the standard of care for following the exact guidelines set out for them, which also is the same protocol for physicians across the country. So for these reasons, Dr. Lenczner's failure to investigate the literature and his refusal to administer Math Plus or ivermectin does not constitute a breach of the standard of care. Any reasonable, prudent, and diligent doctor would have also acted in a manner consistent with Dr. Lenczner. However, establishing medical negligence does not solely rely on determining a breach of the standard of care. And so my co-counsel will now demonstrate that the other alleged element of medical negligence in this case, which is causation, cannot be established either. This will ultimately relieve Dr. Lenczner of liability regarding the plaintiff's alleged claims. Thank you, Your Honors.
Good morning, Your Honors. My name is Orion Boverhof, and with my co-counsel Pearl Bakjtiari, I represent the defendants, Dr. Justin Lucier and West Valley Memorial Hospital. I'm speaking to you today on the issues of causation and vicarious liability. In this case, we encourage the court to ensure that we remain within the scope of the issues and to keep in mind that not every death is necessarily negligent. The first issue I will argue today is one of causation. The defense maintains that Dr. Lucier's conduct at issue, if a breach of the standard of care, did not cause or contribute to Ms. Stark's death. There are two primary reasons for this. First, Dr. Lucier did not assume the care of a healthy woman. Ms. Stark was already in the ICU with a severe case of COVID-19 when Dr. Lucier took over her case. Second, there is no reputable and viable evidence to suggest that Ms. Stark's outcome would be different if Dr. Lucier had treated her with ivermectin or Math Plus. The second issue is that of vicarious liability. It is the defense's position that any breaches of the standard of care, if they exist, were not within the scope of Dr. Lucier's employment at West Valley Memorial Hospital, and as such, the hospital is not vicariously liable for any negligent conduct. My co-counsel has demonstrated that Dr. Lucier did not breach the standard of care by failing to investigate the literature or by refusing to administer ivermectin or Math Plus. Even if this conduct were a breach of the standard of care, it did not cause or contribute to Ms. Stark's death. And when arguing causation, we will focus on the second point, Dr. Lucier's refusal to administer ivermectin or Math Plus. The failure to investigate the literature is a moot issue if his refusal to administer ivermectin or Math Plus did not contribute to her death. The correct test for causation in this case is the but-for test, which requires that the defendant's negligence was necessary to bring about the injury, or in other words, that the injury would not have occurred without the defendant's negligence. The injury in this case is death. The issue, therefore, is whether administration of ivermectin and Math Plus treatment by Dr. Lucier would have saved Ms. Stark's life. And as such, it is important to define the scope of this issue. Any actions taken by other hospital staff before Dr. Lucier assumed care of Ms. Stark is irrelevant to this issue of causation. Whether Dr. Lucier's course of treatment failed to save Ms. Stark is irrelevant if the same would have occurred under a treatment of ivermectin and or Math Plus.
Okay, I'm going to interrupt you. So I'm back on this timing thing.
Yes.
So plaintiff's position is if the alternate protocol that the deceased wanted would have extended her life by 1 second, they have a valid cause of action. You say it would have had to save her life. So is it your position that the alternate treatment would have had to been a life-saving treatment as opposed to the extension of life on a near-death rally for 1 second. What's your position on that?
Yes, Your Honor, that is our position. We strongly oppose the plaintiff's assertion that an extra second would be enough because the injury in this case is death, and they must prove that the defendant's actions caused or contributed to her death, and that without those actions, the death would not have occurred.
So how much time are we talking about?
We would say recovery from COVID-19.
Complete recovery.
Barring any potential ongoing symptoms. Like if, for example, if she lived with ongoing potential shortness of breath, potentially for the rest of her life for 30 years, I wouldn't necessarily call that a complete recovery, but we would accept that as her being alive.
Okay, thank you.
Thank you, Your Honor. Dr. Lutzier's failure to sign the release is irrelevant because his priority was saving his patient and not avoiding liability. The only relevant comparison is whether his refusal to administer ivermectin or Animath Plus specifically created a worse outcome than if he had administered it. Your Honors, it is vital in this case to note that although Ms. Stark was previously a 29-year-old woman in perfect health with no prior conditions, this is not reflective of the woman that Dr. Lutzier assumed care of on October 7th. When Dr. Lutzier first met Ms. Stark, she had a severe case of COVID-19 requiring hospitalization and breathing assistance. The crumbling skull rule states that a defendant is not liable for injuries that would have occurred in any case due to a pre-existing condition. And as such, it is important to be cognizant of Dr. Lutzier's starting point. Ms. Stark was already afflicted with a severe case of COVID-19, which had progressed to the pulmonary phase when she was placed under his care. Therefore, despite the high chances of someone in Ms. Stark's demographic surviving COVID-19, these chances are not reflective of the condition she was in when Dr. Lutzier took control over her care. Additionally, although Ms. Stark may have seemed to be improving after an ivermectin or Math Plus dosage, the surface appearance does not always match what's truly happening within. While Ms. Stark may have seemed more able to breathe easily, this may be simply due to a temporary easement of symptoms while the virus raged within her body. When Dr. Lutzier took over her treatment, Ms. Stark had already developed advanced fibrotic lung disease, meaning that her lung tissue is scarred and damaged. Scarred lung tissue is irreversible. All a physician can do is attempt to avoid any further scarring. A temporary improvement in breathing ability is meaningless if tissue damage continues, and in fact, an emphasis on more independent breathing may put more strain on the lungs. As such, the alleged improvements that Ms. Stark showed after being given ivermectin and Math Plus cannot be taken as evidence that ivermectin and Math Plus were effective in ultimately treating the COVID-19 infection. There is no reputable and viable evidence to suggest that Ms. Stark's outcome would be different if Dr. Lutzier had treated her with ivermectin or Math Plus. The counsel for the plaintiff claims that evidence is persuasive that Ms. Stark would fall into the 23% of late-stage patients who show improvement under ivermectin or Math Plus. However, even if we take this statistic as accurate, there is no basis for this belief. It would be more likely that she would fall into the 77% of patients who do not show improvement. Additionally, the plaintiffs have not suggested that this is a better improvement rate than the treatment Dr. Lutzier provided. And in fact, the plaintiff stated that remdesivir, which Dr. Lutzier provided to Ms. Stark, has a 31% improvement rate. A Math Plus treatment largely focuses on anti-inflammatory treatments such as methylprednisolone, which treats symptoms by preventing inflammation after a virus is bound to cell receptors in the lungs. When trying to prevent lung damage, an antiviral medication such as remdesivir is more important to inhibit the virus before it binds to those receptors. A Math Plus treatment may relieve some symptoms, but would not be as effective at preventing viral infection and replication as an antiviral medication such as remdesivir. The plaintiff argues that ivermectin is an effective antiviral and would have saved Ms. Stark's life. However, the plaintiff relies on low credibility studies and an anonymous meta-analysis that itself carries many issues. World health agencies do not recommend the use of ivermectin to treat COVID-19. The opposing counsel has claimed that the World Health Organization estimated 2 million people could have been saved by ivermectin treatments, but this is false. This is a claim made by the anonymous authors of the meta-analysis, which was extrapolated from a small amount of data provided by the World Health Organization. We note that the World Health Organization has not made any claims about how many people ivermectin could have saved. The expert witness for the plaintiff, Dr. Titchener, claims that there are more studies supporting ivermectin for COVID-19 treatment than remdesivir and other drugs which health agencies have approved or recommended. Even if these studies were taken as credible, ivermectin is not the same as those other drugs. Ivermectin was initially developed as an antiparasitic used to treat scabies and strongyloidiasis. Any literature about ivermectin's efficacy in these scenarios does not carry over to evidence its efficacy for COVID-19 treatment. Remdesivir, on the other hand, was developed for treatment of hepatitis C and used to treat Ebola patients. Its past use as an antiviral and the previous studies demonstrating its efficacy carry over to treatment of COVID-19.
Are you aware that the National Institute of Health's COVID-19 guidelines panel continues to indicate that there's insufficient data to recommend for or against the use of ivermectin, so that you might be in fact overstating your position, counsel?
Your Honor, it is our position that World Health agencies do not recommend the use of ivermectin.
Are you familiar with the National Institute of Health?
I am not specifically familiar.
See, thank you.
The Plaintiffs' Counsel have also drawn a comparison between the death rates of ivermectin and Advil. Advil's death rate, when properly viewed as a percentage, is essentially negligible. Advil was prescribed almost 22 million times in the USA in 2019, and this is in addition to the number of people who use it without a prescription. Ivermectin, on the other hand, is not widely used at all. As a result, despite a technically higher death count, Advil is a very, very safe drug. This comparison conveniently ignores the fact that Advil is taken much more often than ivermectin, and as such, comparing Advil to ivermectin in this manner is unreasonable. Health agencies have not approved ivermectin due to concerns about its efficacy and about its risks. Ultimately, there is not yet any concrete data to demonstrate that ivermectin is more effective than remdesivir in the treatment of COVID-19, let alone that it could have saved Ms. Stark's life. As such, the administration of ivermectin and Math Plus would have changed the outcome of Ms. Stark's treatment is unfounded. This is not to say that Ms. Stark's death was inevitable. There is quite possibly a different course of action, either pre-hospitalization or when she was initially admitted, that would have resulted in Ms. Stark being alive today. However, by the time she entered Dr. Lutzier's care, the damage was done. There is no evidence to show that on a balance of probabilities, she would have been saved by the administration of ivermectin and/or Math Plus, and as such, causation cannot be established in this case. We move now to the issue of vicarious liability. It is, of course, our position that the elements of negligence cannot be established in this case. However, even if Dr. Lutsier is found to have been negligent, the West Valley Memorial Hospital is not vicariously liable for his actions. If Dr. Lutsier did indeed breach the standard of care, that conduct was not an employee act authorized by the employer, as described in the first branch of the Salmon test for vicarious liability. The physician employment agreement between the hospital and Dr. Lutsier stipulates that he must render services to hospital patients in a competent, professional, and ethical manner at all times and in accordance with the current and prevailing medical standards of practice and care.
Council, can I just interrupt you for one moment? And I've read your factum on this point as well, so I do understand your position. What puzzles me a little bit is that it seems that if there is a breach of a standard of care, that puts the hospital in conflict effectively with the doctor. And I'm curious whether it's because you're counsel for both the doctor and the hospital, would it be then the hospital's position that it would effectively not be responsible and therefore the doctor would have to sort of answer for his own errors and pay for or suffer the consequences of those errors? I'm curious where what happens if there is a breach of a standard of care. It would strike me that there is a conflict between the parties.
Yes, Your Honor. It is the defendant's position that the hospital is not liable and that if there was a breach of the standard of care, Dr. Lutsier is solely responsible and solely liable.
Is there a cross-claim filed between the defendants then?
There is not one that I'm aware of.
Do you think that's a good idea? And do you know why you might file one if you're riding two horses, which is in effect what you're doing?
I'm not sure, Your Honor. Your Honors, we also urge the court to consider the policy reasons for imposing vicarious liability. The court in Basley v. Curry outlined two such reasons. The first is provision of an adequate and just remedy, and the second is deterrence. Vicarious liability of the hospital is not necessary in this case for the provision of an adequate and just remedy. Dr. Lutsier is an accomplished physician with more than 20 years of experience, and it is likely that he possesses the resources to compensate the plaintiff fairly for his alleged errors. Additionally, it's likely that he's in possession of liability insurance, which should also be more than enough to compensate the plaintiff if necessary.
And are you aware of the fact, counsel, that the mention of insurance in a tort trial is grounds to declare a mistrial?
I'm not aware of that, Your Honor.
Do you think that's something you might want to be aware of before you made a submission like that, if this was for real?
Yes, Your Honor, I appreciate you informing me.
Continue.
Thank you. A judgment against West Valley Memorial Hospital does not provide any more deterrent for Dr. Lutzire than a judgment against the doctor alone. It is not and should not be the role of hospitals to force physicians to read all literature that may be forwarded to them instead of treating patients in an overloaded ICU. The hospital already requires its physicians to adhere to the prevailing standards of medicine and practice and care. The hospital is not enabling the negligence and cannot be effectively deterred from doing so in the future. Because Dr. Lutzire's conduct was outside the scope of his employment with West Valley Memorial Hospital and was not due to a risk created by the hospital, and because imposition of vicarious liability in this case does not serve the policy goals of deterrence and provision of an adequate and just remedy, West Valley Memorial Hospital should not be found vicariously liable for Dr. Lutzire's conduct. In conclusion, as I and my co-counsel have demonstrated, there was no breach of the standard of care and no causation can be established. Even if negligence were established, this would be beyond the scope of Dr. Lutzire's employment contract with West Valley Memorial Hospital. As such, the claims against Dr. Justin Lutzire and West Valley Memorial Hospital should be dismissed. Pending any further questions, I thank you for your time.
I have a question, counsel. What obligation did the doctor and or the hospital have to allow the patient to make her own choice with respect to her treatment?
Your Honor, we agree that the patient should have some extent of her own agency in choosing her treatment, but we also do not think that a doctor should be required to administer an experimental treatment and effectively test an experimental treatment on his patients where he does not believe that treatment will be effective and where he in fact believes that it is likely to cause harm.
Is this something that should have been discussed with the patient at the time that she was stating her preferred treatment course? Should somebody have replied saying, we're not prepared to do this, and if maybe you need to go somewhere else where they would?
That's a great point, Your Honor. And certainly the optics may have been better on Dr. Lutzire if he had had that conversation. But ultimately, Dr. Lutzire isn't here for bad optics. He's here for alleged breaches of the standard of care, which we argue did not occur.
But with all due respect, there was a week for a transfer before it occurred.
Yes, Your Honor. And it is our position that Dr. Lutzire was not obligated and did not have a duty to make that transfer. His priority again was the survival of his patient, and he believed that ivermectin and Math Plus would not have a good chance for her survival, and he understood that if she was transferred, those are the treatments that she would be subjected to.
And do you support the position of your co-counsel on the cloak and dagger protocol to exclude the patient from decision-making options? That we just leave it to the doctor, and really, you know, in the real world, those patients and their wishes and their end-of-life planning, it's just really kind of a nuisance, isn't it? Because the doctor knows best. Would you agree with that?
Your Honor, it is important to take the patient's wishes into account, and we don't dispute that. But we do feel that there is a line where if the patient wishes for treatment that the doctor reasonably believes is likely to cause harm and that there is no evidence that it would actually help, that the doctor is entitled to make a decision in the patient's best interests as they see fit.
And that's even with a fully competent patient
Yes.
who has wishes directly opposite, they aren't entitled to full disclosure, right? That's your position.
Your Honor, we don't know that the doctor did not inform Ms. Stark of the treatments that she was receiving, I believe.
There's nowhere in the facts that it says that he did.
No, Your Honor, that's true.
I'm very sorry to cut this off, but just for time, we do have to move on. The court now invites counsel for the plaintiff to begin their optional 3-minute rebuttal.
Thank you. We would just like to briefly rebut respectfully the defendant's assertion that the Healthcare Consent Act does allow doctors to override patients' consent in administering treatments. And so Section 10 of the Healthcare Consent Act requires informed consent, and the only section of the act that allows for a doctor to do this is to provide treatment without consent is in the case of emergency treatment, and where the doctor is not able to obtain consent from the patient or from a substitute decision maker. And as we've already mentioned in our arguments, that was not the case here. Ms. Stark initially was fully able to provide consent, and later when she was unconscious, her husband, Mr. Stark, was able to act as a substitution decision maker for her. And that concludes our rebuttal on this matter.
Thank you very much, counsel. This concludes the matter of Stark and Letzier.